Hello, everybody, and welcome to our SVDX webinar for today. We are so pleased that you could join us. My name is Nancy Easterbrook. I'm Executive Director of Silicon Valley Directors Exchange, and we are kicking off our fall season of programming with a fantastic session talking about the regulatory landscape in light of the recent Chevron case. We are delighted that you are here to join us. If you are new to SVDX, I encourage you to go to our website. We have a number of wonderful sessions coming up this fall, as well as a number of recorded sessions from previous months. So go to www.svdx.org to find out more information. Today's webinar will be 1 hour in length, and we will be recording today's session. I encourage you to submit your questions via the Q&A button, and we will do our best to fold in your questions throughout today's session. It's really my pleasure to introduce today's panel. I will do very brief introductions, and then we will begin today's session. Anne Segrest McCulloch is Executive Vice President, Chief Legal Officer, and Corporate Secretary at the Federal Home Loan Bank of San Francisco. As a seasoned financial services and housing industry executive and regulatory attorney with more than 30 years in the industry, Anne previously served as President and Chief Executive Officer for Housing Partnership Equity Trust and held senior positions at Fannie Mae, the U.S. Department of Housing and Urban Development, the Federal Deposit Insurance Corporation, and the Resolution Trust Corporation. Jeff Wood is a partner with Baker Botts. Prior to joining the firm, Jeff led the Justice Department's Environment and Natural Resources Division. He also previously served on senior staff for the U.S. Senate Committee on Environment and Public Works. With over 2 decades of experience in senior government, in-house corporate, and private law firm roles, Jeff helps clients with enforcement, litigation, and policy challenges, primarily in the energy and environmental fields. Our moderator for today, Dan Siciliano, is a successful technology CEO founder and entrepreneur and recognized expert in corporate strategy and governance. He is chair of the board of the Federal Home Loan Bank of San Francisco and currently chairman of SVDX, board member of the Latino Corporate Directors Education Foundation, chair of the Council of Federal Home Loan Banks, and a fellow at Stanford University. Thank you to Anne, Jeff, and Dan, and thank you to all of you for joining us. Dan, the floor is yours.
Great, thanks very much. So I'm excited that more than 8 people would show up to a technical treatment of the Chevron deference doctrine and its evolution over the decades, but I think it's going to be a fun conversation. I think my job was to maybe introduce a little bit of perspective on the administrative state as a whole, and then we were going to kind of kick it off with a little bit more laying of the groundwork, and then get into some, I think, very practical questions for the purposes of what directors need to know. And so for all of you who have not been following the news or modern history, it is worth noting, I think, that the expansion of the federal administrative state is easy to underestimate. And I think probably in just colloquial conversation about politics or government, we obviously are very aware of the expansion of quote unquote the administrative state. But just to give it a little bit of context, I just pulled up a few data points. You know, in the early 20th century, really, there were only a handful of significant and actual federal regulatory agencies. The 2 big ones were Commerce Commission and Food and Drug Administration, right? So that was like 1887, 1906. Not much happened in terms of creation of new agencies from those 2 dates. But during the New Deal era, obviously, Roosevelt, there was an expansion, everything from the SSA, Social Security Administration, the SEC, and other similar agencies where you had a dozen or more by the end of that era, and really kind of 24 if you counted the emergence of these sub-agencies. Post-World War II, another massive expansion, 200 federal agencies by the mid-50s. And then in the, by the 2020s, we now have 400 federal departments, agencies, sub-agencies, et cetera. The real data point that I like to have is the Code of Federal Regulations, which is kind of a repository and compilation of federal regulations, or the Federal Register, which started in 1936, the place that the government publishes its regulations that come from the laws. In 1936, and this is all new publication, so new law, it was 2,500 pages of publications in 1936, which seems like a lot. Except in 2020, that single year set of publications, so every year it's being published, that single set of new publications was 87,000 pages. And it's up from there, but they don't have the final, I guess there's some debate over the number of pages and how to count them. So, okay, there's probably an agency to help us do that. The point being that if you're a director of a publicly traded or large private company, you have many versions of federal government landing on your doorstep sitting on your shoulder, knocking on your back door, sitting with you in the board meeting, making your R&D decisions with you. It goes on. And the question is, has anything changed of consequence in the last year, both in light of recent Supreme Court cases, but also the lead up to that and the kind of political feel and overture? So I think what I want to do after having mapped that out, and I think you were first to just talk a little bit about kind of the legal way in which this stuff shows up at our doorstep and how it happens. And then I think we're going to shift gears a little bit and have Jeff talk about the case at hand. Do you want to go ahead, Ann?
Sure. Congress, in creating all of these three-letter agencies, also decided that we should have a transparent process for rulemaking, that the regulatory agencies should not be able to do surprise, gotcha, secret regulation, shouldn't be able to cut backroom deals with interested parties, but should have a thoughtful, transparent, orderly way of creating regulations. And they would posit, propose regulations. They would invite the public and all the stakeholders to make comments. They could hold hearings around the comments. They were required to review and react to the comments and see if the comments give them real guidance and direction, something they should wrestle with. And then when they publish final regulations, explain what they took into account in reaching this final state. And then if you wanted to challenge a federal agency's regulation as applied to you, one of the first things you would do is you'd challenge whether or not they followed the rules in developing the regulation. Did they publish for notice and comment? Did they take the comments into account? Did they follow all the steps? If they did, under this Chevron deference, they win, realistically. So that has been the playing field we've all been working on. And Jeff will talk a lot more about what Chevron deference is and where we are today. But as long as you follow the transparent process, the agencies have held the cards. And that has meant that all of us as regulatees, because we are all regulatees in every aspect of our lives, corporate and personal, knew what the structure is. Now we're in a different world.
And I think I've heard someone describe the rule promulgation process through the Federal Register and the comment period is kind of like one of the earliest forms of crowdsourcing by the federal government. It's not all negative, right? It is oftentimes a nuanced input process where it says, hey, did you think about this? Did you do that? Academics sometimes get together and write a bunch of comments. Trade associations write a bunch of comments. The regulated entities obviously write comments. And then sometimes you get kind of Joe Citizen, throwing stuff in. I point that out because we're going to weave in who matters differently than they did maybe 6 months ago in this narrative, all the players who kind of can or should stand up and say, wait a minute, or I have a thought, or I'm going to sue you back, sort of thing like that. That'll be one of the very practical questions, which is what can a director do or not do differently than 6 months ago, and or what can their allies do differently than say some time ago. But with that, Jeff, why don't you walk us through maybe.
Let me jump on that really quickly too. So, and give two sort of data points. Many years ago, probably 40 years ago, it was not uncommon to see rulemaking regulation gets published and the regulator would say, the public objected to these types of requirements for shrimp fishing nets and said that those would affect too many other types of fish. And we got 300 other similar comments. We've rejected them all. The courts have been clear for quite some time that that's not a sufficient taking into account of the public comments. And so agencies do have to and have had to be serious about what's come through the door. And when I was on the regulator side, when I was the regulator, as Dan said, It really did give you real information about the potential unintended consequences of what you were proposing or the larger impact. So I found it to be a really helpful process and helped educate me. I think it's also worth noting that it is not uncommon that many of the people in the federal agencies who are working on these matters have not actually been on the other side. So as someone who thought I was the smartest housing regulator in America with no actual practical applied experience, didn't even own a home, it's helpful to learn from others who've been there.
Yeah, and I think, Jeff, the intro to you is to say that this recent decision, which I know you'll talk about, is not an indictment of the historical process or the methodology that's in place. I mean, the Administrative Procedures Act is generally well thought of. We all complain when the regulator doesn't go our way that they violated it at some level of spirit or fact, but it's not an indictment. It is a change, arguably, in the direction of who gets to say what when. So why don't you give us what is the case that we're talking about, but feel free to go back all the way to 1984 with Chevron.
Well, let's start back 40 years ago in 1984. Interestingly enough, in 1984, the administrator of EPA, which by that time had been around, not much more than 15 years, the administrator was Ann Gorsuch during the Reagan administration. And interestingly, Ann Gorsuch had a particular interpretation of a Clean Air Act provision that she wanted to promulgate, which she did. And that regulation was challenged by the environmental community as being an improper interpretation of the Clean Air Act. And the Supreme Court eventually hears the case in 1984, and the court adopts what we now know as the Chevron two-step framework, which essentially says, when you look at the statute, if it is ambiguous, you look to what the agency has interpreted the statute to mean. And if the agency has put forward a reasonable or permissible view of what the statute could mean, the courts would defer to it when that interpretation is embodied in something that's gone through notice and comment rulemaking. But if you back up a little bit and you say, well, in the first step, if the statute is clear and unambiguous, then the agency doesn't get any, quote, deference. So that was the framework the Supreme Court adopted, and interestingly enough, upheld the interpretation of Administrator Gorsuch and put forward the Chevron framework. Now, ironically, 4 decades later, her son, the Supreme Court Justice, Justice Gorsuch, is one of the 6 justices who overrules Chevron, which happened, of course, this summer in the case known as Loper Bright. But before I talk a minute about Loper Bright, I thought it was interesting to comment a little bit on what you said about the administrative state and what Chevron was actually doing. I mean, on one hand, it was protecting the right of a new administration or an elected executive branch to go a different direction, right? To adopt a new view of a longstanding statute and take things a different way, so long as it was within the bounds of what's reasonable and permissible when you had an ambiguous statute. It sort of helped grease the wheel, so to speak, of democracy in that way. But on the other hand, it was in tension with the constitutional principle that courts decide what the law means, right? And ultimately, the Supreme Court has most recently come down the side that judges say what the law means. But during the Chevron era, there was a Congressional Research Service report that cited a survey that found 88% of agency rule drafters either, quote, agreed or somewhat agreed that Chevron made them more willing to adopt a, quote, more aggressive interpretation, which makes sense, right? When you're in an agency, if you have Chevron deference, you have courts saying, hey, so long as you give us a permissible or reasonable interpretation, we'll let you go with that. It led to agencies being more aggressive, which also led to extensive litigation, right? Challenging all hosts of regulations, which adds uncertainty and costs to the whole system. So that brings us to 2024. Of course, we've had decades with Chevron in place, and the lower courts deferring in large part to agency interpretations. In Loper Bright, the Supreme Court was facing the question of whether the Department of Commerce could require Atlantic herring fishermen to pay an enormous fee to have on-boat fishing or fish catch monitors, essentially bringing on government monitors to make sure that they were following the fish catch limitations that were in effect. Those monitors were costing up to $700 per day, a reduction in profit for those fishermen of about 20% on their daily profit, and was based upon a somewhat questionable interpretation of the underlying statute. So this case makes it to the Supreme Court and becomes a pretty good vehicle for the 6th Justice conservative majority to reconsider Chevron. And ultimately, Chief Justice Roberts, in writing the opinion, explains that courts must exercise their independent judgment, that they are the ones responsible for looking at a statute and understanding whether the best and correct interpretation has been put forward by the agency, and that it is not a proper role for the judiciary to quote unquote defer or delegate that authority over to agencies. Now, they didn't say they're going to throw everything out. It's not that an agency says something and courts are going to ignore it. Even though they won't defer to the agencies, they will still give the agencies what the courts have called respect. There've been a line of cases where the court has said, look, if an agency is going to adopt a new interpretation, we'll give it the level of respect that it's entitled to. So that's where we are today. We're in a world where there's no longer straight up two-step deference, but you have respect for agency interpretations that deserve respect.
And Jeff, let me ask a couple of follow-up questions kind of from a non-pure legal viewpoint. And one of them is that it sounds like, at least for a while there, Chevron deference was, at least in the most optimistic view, an expedient way to adapt to changing times without having to go back to Congress and get them to update language. I mean, whole things might have been invented and we didn't have names for it. So it at its best, it kind of had that. But per the survey results that you described, at its kind of average, it simply became a way in which agencies might lean in or expand over time the aggressiveness or the scope or both of what they're doing, which is a separation of powers issue, really, right? Because Congress is reserved to make it law. So again, and this is a question I have for you about your practice and the way, you know, people interact with you and think of things. I don't think lots of boards, and it's no one's fault, distinguish between lawmaking. So you're lobbying Congress, you're talking to representatives, you know, eliminate this law, make this law, and rule promulgation, right? Which kind of spells it out. And do you think that management and boards should be now paying more attention to the differences between I'm lobbying Congresswoman X because I really want this put into this rider and I want this language that creates this new thing for us, versus I see that this agency just put out an advisory bulletin and I think maybe they should promulgate a rule. And by the way, I'm going to pay close attention to that, because if they deviate too far from the kind of ambiguous language, I have other options. So I don't think people think differently about those two things. Do we need to bother, or is that a relevant difference?
I think we absolutely do. And I think one thing I would encourage board members to consider, as well as those in the C-suite, is engaging with Congress to ensure that clear law is put in place, recognizing that agencies are not the best place to look to for answering the big political balancing questions we face. But also doing that in conjunction with your trade associations. I mean, maybe there is a longstanding statute that you in your industry are required to operate under, and there are some important questions that need to be answered as to how you should be regulated. Well, that primarily should be a congressional lawmaking question with some filling in of the blanks, right? Filling in the gaps that agencies can do. But you need to be looking primarily to those, to Congress for that. On the other hand, if an agency has been adopting or implementing an interpretation of a statute that affects you, that governs you, and they've been doing so in a way that maybe it's somewhat in the realm of permissible or reasonable, but certainly isn't the best and correct interpretation of what Congress meant when they put that into place, that's something that your trade group might want to talk about challenging. You and other members of your industry may want to get together and consider whether that's appropriate to challenge. You know, there's a long trend here with other Supreme Court cases where the Supreme Court has said, I mean, kind of clipping the wings of the administrative state, so to speak. You know, Chevron's gone, replaced with Loper Bright, no longer deference, now have respect. But the court has also done things like if it's a major question, if this is a major economic or politically significant issue. The Supreme Court has said recently in a case called West Virginia versus EPA, that is not for the agency to decide in the first instance, that's for Congress. And if an agency is asserting authority over a major question, the Supreme Court's going to approach that with severe skepticism. So there are some opportunities, I think, to look at your federal relations and figure out a path forward.
You know, Jeff, I'd jump in on that though, because I think one of the unintended consequences of this is we're going to see more regulatory looking statutes. And, you know, instead of having a broad framework in the statute with all the level of detail in the regs, you're going to see a lot more detail in the statute. And statutes don't have to go through notice and comment rulemaking. Things can move quite quickly occasionally. Particularly if it's something that you can throw onto a must-pass piece of legislation. You could, you know, those last 24 hours in a session are kind of a madhouse. And if you get something onto the defense bill or something. So I think there's going to be a lot more churn at the congressional level. And it'll be interesting to see how we feel about this.
Yeah, and
In
makes
fact,
it more important to actually be present and part of that conversation, right? If you're not at the table, you're on the menu, so to speak.
Yeah, Jeff, let me ask, and a follow-up to that. So it feels like, therefore, the better lawmaking is not necessarily a natural outcome of this change, because the lawmaking still going to happen. And the Chevron wasn't overturned insofar as the first step is concerned, right? So if there's clarity, even if it's a bad law but clear, then there's not a lot of room for the regulatory agency or the court or anyone to change what they wanted to have happen. And I think that highlights your point that maybe this will have the effect of causing Congress to be more thoughtful about clarity and, you know, being better in the first instance, but it also might mean that you get very clear things that you don't want. And that's always been the case, but I think it's a good point. And so that begs the next question, which is, you've mentioned uncertainty, and I wonder if you can make the case in both directions, like what is now more uncertain versus what is more certain? And then is there a new way of looking at the tools at the disposal of ultimately the board, but as a practical matter, the management? And I know both of you have thoughts on this. So maybe, Anne, do you want to go first about it's just extending what you just said, I think, the certainty versus uncertainty, and then maybe we talk a little bit about what directors should think about can be done or not be done compared to previously.
So certainty versus uncertainty is going to be, we're definitely going to be in a world of greater uncertainty. That's a given. And when I think about this, I think of the different hats I've worn. When I represented advocacy groups, you know, suing regulatory agencies was your bread and butter, alleging they had failed on many, many counts. And this decision will be a real powerful tool in the hands of the advocacy groups, because you've taken the thumb off the scales in favor of the regulatory agency. They have no reason not to sue the regulatory agency, so it's game on. And I think you're going to see a lot more challenges that can either come from completely independent advocacy groups or could come from the trade associations. And I think we'll see a lot more there. Among the regulators, the stat that said they felt empowered by Chevron deference. I don't think they'll act differently. I don't see it. I don't think the lack of Chevron deference will lead. You know, they try to follow. You know, if they're actually going through APA notice and comment rulemaking, they follow the process in most cases. So, and they have strong beliefs that they are headed in the right direction and that their view is correct. So I don't know that they will change with aggressive rulemaking and interpretation. I actually think it might change their behavior more in the non-APA space, potentially. all the things that fall that they do through advisory bulletins, through exam findings, through all, private letter rulings. For I think that'll be we'll see more change there. But then for corporate counsel, on the predictability versus lack of predictability, the thing this opens up for me is in a defensive setting, if the regulator's coming after your client, you're in a better position now. You are more positioned to challenge what they're doing if you genuinely think that they've misstepped here. And if you're in a defensive posture where they're coming after you, you can put a lot more thought into fighting back than you might otherwise. And that's actually, I think, a change.
Well, that's a happier note. Everything right up until then was not exactly great news, but maybe Jeff, you can expand a little bit on that point. Like, what's your analysis about, the ability of clients, regulated, entities to defend themselves from like overreach, perhaps, versus alter the course of how they are regulated on a day-to-day basis? Maybe expand on that a little bit.
Yeah, and I think first, just in terms of your other question about, are we looking at broad changes in certainty and uncertainty? I think my own sense is that in the near term, we have significantly heightened uncertainty as this dynamic plays out, where there's going to be an increased tendency to want to challenge agency overreach in these contexts. But I think the overall goal, at least for the justices who supported overturning Chevron, it is to increase long-term regulatory stability and certainty, because there's less leeway for agencies to be as aggressive as they might otherwise tend to be. One of the things that ties to that last question about, opportunities to challenge these actions, the Supreme Court in another decision this summer called Corner Post, which is kind of paired up with Loper Bright, essentially opened the doors to a longer time frame in which you can bring a challenge to an agency action. It's not judged based on the time from when the agency rule was adopted. You have a 6-year statute of limitations to challenge agency actions under the APA, and that time begins to run when the party is harmed by that regulation. So it could be many years later. So you might be able to do a much longer look back to bring some challenge to even agency action that's not very recent in and of itself. So I think it's important to keep it in mind with all of that. My own sense from my experience inside the Justice Department, which is tasked often with the unenviable responsibility of defending agency actions in federal court, and they often advise the agencies on where those lines are between permissible and reasonable. In the context of advising agencies, Chevron provided a very sort of comfortable, happy spot to land, right? Because as a lawyer working in the Justice Department, you can look at an agency's policy preference and say, okay, look, that's not the interpretation of the statute I would have adopted. And I have problems with that interpretation of the statute, but it's permissible, it's reasonable, and it's an ambiguous statute. And it provided some comfortable spot for negotiation within the executive branch to come to a resolution that all could get their arms around and agree to defend. Now you're in a different world. You've got to get all the lawyers on board who are defending your interpretation, and they've got to be willing to say in federal court on behalf of the United States, this interpretation is the quote best and correct interpretation. And those are grounds on which lawyers are going to debate fervently. And you're going to see that play out probably more in the background, not on the pages of the Federal Register, but eventually in court as lawyers have to defend these decisions.
I want to jump in and ask both of you to weigh in on what you just described, because I think it's not obvious to the average high-performing director, even at a big, highly regulated company, what you just described, which is there is within each agency several, centers of power. One of them, which is kind of like a marathon center of power, it's always there, sometimes it's stronger, sometimes it's weaker, but it's always there, is the general counsel's office or the equivalent. And that general counsel's office, I think a cynic would say, what do you mean? Why does that matter? Aren't they just going to do the bidding of like the politically appointed director? And, you just described this thing where the lawyers are going to self-censor. I'd like you to expand on that, because I would say, even as someone who kind of paid attention to this as a living until I was in the middle of it and observed it, I did not fully appreciate how much general counsel's office might push back internally to the policy aspirations of an agency. So could you describe that? And then I have a follow-up question about why that matters to strategic issues for directors and kind of these big issues. So Anne, maybe you go first, because I know you've been there.
Let me
And
start,
Jeff,
'cause
I know you've done it.
Yeah, I was in the agencies, not at Justice, and Justice sits in a different place. But when I was I was in multiple agencies, and in none of them was I in the general counsel's office. I was a program person. And to use HUD in my tenure as an example, there were multiple centers of power. The program people were the people who were writing the regs, who are developing the policy, who had strong views. We didn't speak with the general counsel's office very often. As a matter of fact, we avoided them in the halls, didn't talk to them at lunch. You know, we were our own world, and occasionally we were compelled to speak with them. But it just wasn't, it was not the sort of partnership that I've always had in private, you know, in-house and in a corporation. I mean, we were truly separate. And then the other side of the house was that, you know, when you would talk with the lawyers, they generally were very clear that they were better at writing the law than we were, as they should have felt. And that whatever we were doing in the program shop was just flat wrong or wrong-headed. And if you ask them, we shouldn't have done it that way, but we didn't ask them. And so we went ahead. So again, you get those two, you know, the lawyers may well not have been consulted about a lot of elements of the reg writing process. And then the reg goes final, you're applying it, it's the rule. And someone challenges you. You know, you've taken enforcement action against a third party, you've cut off some subsidy, whatever. You're either affirmatively going after someone or defending against them coming after you. And in general, you then have to go to the Justice Department to look for a defense counsel. That's not often done just by in-house general counsel's office. And the Justice Department has to be willing to defend you.
Yeah.
And they may not. As a matter of fact, often not.
Right.
You know, they may be very much of the what were you thinking school, and let us help you settle this right now school. Again, not all the time, but those are not unrealistic dynamics.
And the balance will have tipped in favor of that, what were you thinking reaction, and let us settle this now, because the deference is minimized, if not gone. So Jeff, how does that play out as a strategic matter in boardrooms and with management who have big things at stake, right? Either, you know, a subsidy that they are worried is going to be yanked away, or a prohibition that they think is inappropriate and prevents the expansion of a whole line of business or growth. Like, how does that new difference play out in terms of how you might think about strategy?
Yeah, I think in this Loper-Bright era, where lawyering plays a elevated role in ensuring that regulations are built on the quote best and correct interpretation versus just some permissible interpretation, becomes much less about the policy explanation for why you're doing something and much more lawyerly in that sense. And so I think for the board members, I would encourage them to consider ensuring that your teams are putting forward the best and correct legal views and legal interpretations, and ensuring, to the extent agencies are going through a process to adopt those, that you are helping contribute to that sort of analysis to ensure longer term durability for decisions that are made. And I think that even within federal agencies, I mean, they're not all the same. And I think Anne's had experiences with some, and I've had experience with others, worked a lot with the Department of Energy and the EPA and the Department of Interior and these other agencies where they have very large general counsel's offices, but there's also lawyers upstairs from them advising the key decision makers at the secretary level, the cabinet level. But then beyond that, the sort of nerve center of the federal government is the Office of Management and Budget. And there's not a major regulation that gets adopted that doesn't have to get blessed or reviewed in detail by that office, and then ultimately blessed and approved before it can be adopted. And within that office, you have significant analysis, both on the data side as well as the legal side that happens, and lawyers playing a role there as well. And then ultimately DOJ, if you're going to litigate and defend it. But I think bringing the statutory tools of construction, what we, as lawyers know, when we read a statute, how should you properly interpret it? And then put those best arguments forward is really where the rubber meets the road now, I think, in this Loper-Bright era.
Let me ask a follow-up that maybe ties to that, and that is the calculus of M&A, either acquiring subsidiaries. We played this game, which was fun when we were prepping, and I've since now played it with everyone I can get to play the game, which is, hey, name something that you don't think the government has the ability to regulate or show up and talk to you about, right? And I think I've lost 1 out of 10 times, and it's just probably for my lack of creativity. But anything you can come up with has some sort of intersection with the administrative state. And so it's been a long-stated best practice among boards to say, understand what regulated intersection you are acquiring, even if remote or non-obvious, right? Put that in the calculation. But now it actually, that calculation is still there, but you can have situations where a less well-capitalized enterprise that could not muster the $50 million to fight back on the thing that really mattered to them and made all the difference. And maybe they're on the side of right, but they just couldn't do it. You, a better capitalized entity, can acquire them. And now it's $20 million to win that thing, right? So can you talk about the surprise intersection with newly regulated entities after you acquire something? You're like, wait, we're a what? I didn't know that. And then how that plays out in the new era of Loper-Bright with arguably some more defensive arsenals available to fight back, overturn, overreach.
Yeah.
Who wants to go first? Either one. Anne has great stories about how people accidentally became a bank. That's my favorite one. It's like, oops, we're but Jeff, Jeff, do you want to, or either one, either one.
It's a particularly shocking one. When I saw it and when the acquirer paid attention to it, under the, I don't know if it's still current, but it used to be that if you were a lender in the apartment finance business and you got a license to be an FHA lender, which means that you're an ordinary private company, you're making loans to these apartment owners, and FHA will insure that loan. So that makes it obviously a much better investment for people who buy mortgages from you. It makes it a better investment for you in your own hands. And a lot of the participants in that industry were mom and pop shops who built their own mortgage lenders, knew the apartment business, took on the risk, knew how to manage it. And then that business became very, very lucrative and increasingly complex. And the largest financial services companies started buying those businesses. The big name insurance companies and banks that you hear of every day. And I was talking with the general counsel of one very large company who had bought one very small FHA multifamily lender. And he talked about all the due diligence they had done and the assurances that they had gotten that there were no particularly noteworthy risks in having an FHA lending program. And his surprise when he saw that the FHA contracts specifically made the lender a fiduciary of the federal government, with all that implies in making loans to apartment owners and in accepting FHA insurance on it. And it took an ordinary commercial transaction and made it into a profound trust relationship with nearly unlimited potential exposure to the parent company when you think about it. And really, they had to think about their work in different ways. And then as we've seen play out over the last 15 years, many big companies were surprised to find that they had done quite a good job of dealing with their primary regulator, and then all of a sudden they were in consumer mortgage hell, because they they didn't know how to play in this space they had joined almost by accident.
And I think, and I'm going to ask Jeff how to turn this into like an arbitrage opportunity, but let me expand on that, kind of applying some modern day dynamics, which is, I think you have a lot of very large pre-IPO companies that, how to put this in a positive light, and I mean it this way, have immature but aspiring to be better compliance departments, right? Like it's just a fact of life. Like if you've gone from 100 people to 2,000 people and, you know, $18 million of revenue to, you know, $1 billion revenue in 6 years, whatever you've built, no matter how hard you try, it's doing so in best case. And those companies in turn are rolling up other, in this case, maybe fintechs. And those fintechs, no ill intent on their part, but they probably haven't identified the fact that when you give people capital and ask for it to come back later with some extra stuff, that is lending, no matter how you name it. And hence you really are, you know, under the jurisdiction of any number of things. So that kind of roll up and activity, you know, if you go from a less compliant space into a more compliant space, you're sometimes surprised. So we've known that's happening in real time with companies. Then in turn, maybe a big public company buys the almost IPO company, and then it gets really complicated. But what are the opportunities, I think, Jeff, is my question to you. And more importantly, how can a director sort out these opportunities? It's also, if you're not a lawyer, and even if you are, this all feels very overwhelming. It's like, okay, I'm supposed to be reading the Federal Register, and that supposedly it has like 1 million pages, and the CFR, and I can barely form questions that I understand answers to from my general counsel as it is. Like, what the heck do I do in this new world of less Chevron deference? Like, what things can you do? So could you, feel free to riff on any part of that.
Yeah, no, I mean, I was going in the direction of, you know, where do I see this dynamic play out with regard to, you know, a deal where you have some legal issue that comes up that surprises you, and how do you deal with it? What are your options? And oftentimes in the, you know, we do a lot of work in the energy and technology space, and you might have acquisition of an energy facility, and somebody might think, well, we can make a particular kind of change, right, to this operation, a modification to a facility, without really thinking through the consequences of that change. So perhaps you are then triggering a significant new obligation to install the state-of-the-art, best available pollution control technology that might cost you another $1 billion, fundamentally changing the nature of the deal. You might acquire a facility or acquire a company that has some sort of long-standing consent decree or settlement agreement with a federal agency or the Department of Justice that requires you to do a lot of things, like a compliance management system that has some additional legs to it, or could require you to comply with some new obligations you weren't really thinking about before. And so we see it come up.
To clarify that pattern, by the way, just so if people aren't familiar with the space, it's a common regulatory strategy in a vague law to say, in order for us to improve A, we'll approve that. But now, since you've done this, you now have to upgrade or update all of A, B, C, D, and E. And so like the $100,000 thing, which was a net good, right? It was good for everybody, is actually creating an obligation to do other things that might be good, but are on a capital scale maybe you didn't anticipate it. This is a very common pattern found throughout all of regulatory space. So that's kind of what you're talking about.
That's right. And in a lot of those settings, that interpretation that requires you to do something bigger and better than you might have anticipated before has often been built upon sort of the reasonable, permissible interpretation of statutes, and less so on the clear, best, correct reading of the statute. And then following that sort of storyline further, Dan, suppose you have that situation and you commit some sort of technical violation. Well, the government comes after you, says you violated it, puts you under a consent decree requiring you to come into compliance. And sometimes those decrees might last for 3, 4, 5, 6 years or longer, up until the time a federal judge thinks you've done enough to get out from under it. And those also act like another layer of law, right? And how you interpret and comply with those requirements. And so we see this come up in our, in our energy and environmental sort of work. But you might see it in a whole host of other spaces. I think in terms of how it plays out and what options are available to you. I mean, there is no end to the number of opportunities that are out there for ensuring that agencies are operating lawfully. We see a recent example with the IRA, and one of the things, the Inflation Reduction Act, and a significant infusion of funds into the economy, a lot of it geared towards energy expansion or energy transition kind of scenarios. And we're seeing a lot of investment come out of that, especially in clean energy technologies. But there was a lot in that law that was left unanswered, or perhaps answered, but not in a way that the current agencies implementing it would want to, follow that way. And so they're looking for flexibility. And so this is going to play out, I think, in that battle, in that context, as well as many others. I have a partner who's in the tax department here, Eli Hinckley, who's really written and talked a lot about this dynamic of how do they implement the IRA in light of Loeb or Bright, and does it give them more flexibility or less flexibility? And there's a host of other scenarios where we'll see it play out.
So I want to describe that
Some
pattern.
of that too, the other way, right? Which is what you're pointing out is that there will be opportunities to invest by looking to see what areas have been overly regulated, that you could then challenge the regulation if you had the money
Right.
now, and have a shot at it. And so while I've worked with family offices who are looking particularly for investments where there are high barriers to entry, because they knew they could learn the space and that would keep other people out. Now it's kind of, in this case, you're looking for industries where you have a chance of knocking down those barriers to entry and change the landscape.
And I want to describe a generic version of that pattern, which economists talk a lot about, but I don't think it appears in this space as often. And it's we jokingly say the yes, but also. I'll give you a yes, but you must also, or it's an all or nothing, or anti-cherry picking, or no narrow optimization. And those are all opportunities to deploy lesser amounts of capital to achieve a return on investment that in a silo is a great deal, but no one's thinking of it that way anymore, because for a decade or two or three, you haven't been allowed to cherry pick, narrow a silo, do the one thing. And that, I think, is a pattern that shows up in lots and lots of industries. I think, energy production is a really good one because it's so clear. But I think that the question I have as a follow-up then is, what is it that the board should be asking of management, or is it general counsel? Like, what is that interaction like if it's different or a little better than average? Like, what do you do? And what committee does this even belong to? Is it like, how does this manifest, other than a director says, I'm going to take it upon myself to ask good questions about this Chevron thing and the opportunities it presents, which seems unrealistic to me. So how does this manifest really in the boardroom at the appropriate level?
And my thought on that is, it goes to the nature of the role of lawyers in government and ensuring that, as it relates to impacts to your industry, that the best lawyering is brought to bear, right? And it goes back to the earlier point I was making about the durability of agency regulations that govern your industry. And so I think there was a tendency maybe in the past to sort of throw your hands up and say, well, the agencies are going to do what they're going to do, and the courts are just going to let it happen. And we have to sort of live with that reality. And now it's not so clear that's the outcome. If an agency is truly acting outside the range of best and correct legal interpretation, there's some exceptions to it. I mean, you got to have some nuance to how you look at that. But for the most part, you're kind of operating in that regime. You're asking your lawyers, is this consistent with the law? And is it subject to a challenge? And not just a challenge in a court in DC, actually maybe a challenge in a court in your own backyard, where they might understand and have a greater appreciation for the kind of impact this has on you and taking it seriously. So I think that's a place where the board can ask questions, and whether that's the governance committee or another committee within the board structure that takes that up, I think it's an important question to ask.
Dan, where I'd be looking at it is whoever looks at your new products, innovation, further out corporate strategy, and that's different in every company, but a lot of the companies I've worked in or with have designated innovation shops, right? Who are always looking at products, programs, initiatives you can roll out in the near term, medium term, long term. And a typical component of those shops has not been scanning for areas of overregulation where you could get a change and crack open a market. But now it needs to be.
Yeah.
And that's not going to be this week's, but it's going to be in your midterm to long term. and they should just be scanning, again, in the adjacencies for what they're already doing.
Yeah.
I
We're
have an
gonna-
interesting sort of thing that connects to that, Anne. I was reading a McKinsey report recently that dealt with the need to drastically increase the amount of energy production in the United States, and hopefully from lower emitting sources of energy. And they identified 6 what they call bottlenecks to making that level of energy production happen. And you could translate this to any sector, I think. But the bottlenecks were things like materials, land, infrastructure, cost competitiveness, and the like. One of the bottlenecks that was missing, I thought, was regulations, like regulatory bottlenecks. But if you think about each of those bottlenecks to your market or to profitability, they all have an inherent regulatory cost associated with them. And so I think you could look at each of those things that are maybe hurdles or bottlenecks or constraints on achieving your objectives and ask the question, how do regulations play into this? And what opportunities might be available today to revisit some of the quote unquote regulatory bottlenecks that might be hindering the market you want to tackle.
This is a great segue to a question we've gotten, and I do want to encourage people in the last 7 or 8 minutes that we have, maybe throw out some questions if you have them. We've been kind of skipping around, and so I suspect we've covered a lot of questions that people might have had. But if you have one, please post it, and we'll try to get to it. But the question was kind of a broad one, is kind of a policy optimization question, and that is, do you think this change will in fact drive more private sector innovation, and where can directors lean into that perhaps? And you just hinted at it, right? Which is you have every bottleneck is at least in part regulatorily centered, right? Like almost any bottleneck you come up with, right? But yeah, do you think net it'll increase innovation? And if so, what, and you already gave a suggestion, scan the places where you got stuck before and ask, ooh, can we push again? What else could you do? What do you guys think? Yes or no on innovation?
I'm glad you said.
Can I say
Fine.
one thing? It
Yep.
kind of depends on whether or not you've really had the luxury of being protected from the rest of the world by your regulations. And if that's if funded a lot of your innovation and your business model, because that can change too, and that might not be your happy space, because your competitors and market entrants may be fighting those walls that have been keeping you safe, and it'll be interesting to see. Obviously, you're going to want to focus on things where there's a big federal hit. And I can use an example. The apartment finance business estimates that the cost of new apartment production has somewhere between 20 and 45% of all costs are directly related to regulation. But it's not a one-stop shop. It's lots of different little local things, state things, and then a little bit of federal stuff. So you can't get a quick hit by fixing that. Be looking for the quick hit that this applies to, federal regulation, where there's a big rock you could break up.
Jeff?
Yeah, I'm glad you said net, because I do think, on one hand, there is going to be an opportunity for increased innovation because you're moving the power center away from the agency and toward the private sector, because you're reducing the discretion the bureaucracy would have insofar as they're regulating. I think on that hand. On the other hand, it's not uncommon to want to go to your regulator and say, hey, it would help if you kind of made this requirement a little less onerous, or maybe gave us a different pathway to move with regard to our commercial activity. Well, the agency has less flexibility now to fashion those sorts of approaches. So I think net, yes, it does help drive innovation because you're moving power center away from the bureaucracy and more back to the private sector. But it's not going to be the case in every context. There are places where less flexibility will mean you've got to spend more time and effort in getting Congress to move the needle as opposed to the agency.
Great. So I'm going to shift gears and ask you these are my go-to questions I tend to ask. What one thing, and we'll start with this one. What one thing do you think that is showing up in the discussion around this change that you think is either wrongheaded, misdirected, or just an outright red herring? You want to say, listen, that thing, just don't pay attention to it. Don't lose sleep over it. It's just not something you need to worry about. So that's my first question. My next question will be, what's the one thing you think we should all do, tomorrow? So first, Jeff, you want to go first on the red herring question? Yeah.
Yeah, I mean, I think, I sort of liked what Justice Kagan said when she, in her, in her dissent, essentially said that it's a jolt to the legal system. I think she probably had the right instincts there, that this is a jolt to the legal system, but I think I would disagree with her insofar as how far does that jolt go? I think there is a real limit to how far-reaching Loper-Bright will be. I mean, ultimately, I think going back to a point I made earlier, the majority views it as an opportunity to increase regulatory stability because agencies will have less flexibility, rely more on the lawmaking branches to dictate what happens, and that hopefully over the long term is what happens. So I think if you hear people talking about, oh, this is cataclysmic, or this is the end of the lawful order that we've grown accustomed to over the last 40 years, I think that's overreach and overstating things. And we're going to work through this, and agencies will better understand they need to have a stronger legal position for their views as opposed to a policy type permissible interpretation.
Yeah, but Jeff, no one will retweet you if you say, this is important, but not the end of the world. It's probably going to work out okay. No retweeting of that. But no, I appreciate that. I like it.
Not cataclysmic.
A very balanced view. Okay, yeah. And what about you? What do you think is the red herring here?
I've heard a lot of woohoo. The chaperones are gone. We got the car keys. We got the beer. It's going to be a whole new world. I can be challenging my regulator, and you're like, yeah, no. You're going to be spending a lot more time with your trade associations because you're still going to want strength in numbers. Yeah. You're still going to have to work very effectively and productively with that regulator for all of time. So yes, if you're on the defensive, you've got more tools. Yes, if all of you want to line up and fight for a change collectively, but I'm not seeing this party out of bounds moment occurring. And I've heard many junior corporate counsel in different businesses going, let's take them on. And you're like,
No, that's great. I like that advice. And I'll throw out one, which is sometimes you commentators say, see, this is just evidence that we have this terrible administrative state. It's creaky, it's disastrous, it suppresses everything from freedoms. If you've spent any other time in any other country engaging in either commerce, policy, or otherwise, you recognize that our system is flawed in many ways, but boy, transparency, order, consistency, reliability, adjudication, if you're having a bad day, just Google administrative bureaucracy and put any other country in there, and you'll feel pretty good. So on that note, I want to ask you 30 seconds or less, what's the one thing that you think a director listening to this now should do right away? And it can be ask your general counsel this, tell your other board members that, read this thing, don't do that thing. Anything's good. So maybe give me a one action item for sure. That's the please do this, you would say. Who wants to go first? Jeff.
I'm happy to go. I would say again, engage with your trade associations and with the litigation components of your trade associations, whether in DC or partnering together with other companies in your industry to evaluate whether there are particular regulations that are now susceptible in light of not just Loper-Bright, but the whole suite of Supreme Court decisions that have come out in the last few years, Corner Post, West Virginia versus EPA, and the other decisions that would help show a trend away from the administrative state and towards more discipline in terms of what agencies can do. And so I'd encourage you to engage with your trade groups, figure out what those opportunities might be, and consider whether it makes sense to challenge them or strategically work around them.
Thanks. And 30 seconds or less.
Your government relations team, spend more time with them. They should already be a strategic business tool and aligned with the corporate strategy, but now they really are. And you want to be spending more time with them on that basis to see what opportunities they can create for you.
Sounds like a whole nother webinar, how to build, engage with, and help management support us in government relationship. Anyway, I want to thank you so much for turning what might have looked like a dull topic into a fantastically exciting hour. I really appreciate your time, and thanks again. Thanks, Nancy, and thanks, everybody.
Yeah, thanks, Dan. Thanks, Ann. Thanks, Nancy.
Bye-bye.